In order to understand the nature and essentials of marriage, one should know the essentials of marriage and its effects. In this lesson, we will discuss forms of marriage, that is legal requirements, classification of marriage, legal effects of valid marriage, enforcement of conditions of marriage, and restitution of conjugal rights. The legal requirements of a Muslim marriage are proposal, that is Ijab, acceptance, that is Qubul, guardianship, that is Wilayat, representation, that is Wakalat, and witness, that is Gawahi. Ijab, that is proposal. The intended marriage between two persons should first be proposed by or on behalf of either party thereto. This is called Ijab. Qubul, that is acceptance. The proposal so made should be accepted by or on behalf of the other party to the intended marriage. This is called Qubul. Form of Ijab and Qubul. The expressions conveying Ijab or Qubul must be reasonably certain so as to result into a completed transaction. They must not convey a mere intention or promise to marry. Wilayat, that is guardianship. As regards those who are not competent to contract their own marriage, Ijab or Qubul, as the case may be, is to be made by their marriage guardians, that is Wali. In Shafi and Ismaili laws of marriage, guardian is also to act on behalf of a girl who has attained puberty, unless it is not her first marriage. In Hanafi law, a woman who has attained puberty can act, if she so desires, through a marriage guardian. Wakalat, that is representation. Those who are competent to contract their own marriage can make Ijab or Qubul either personally or through a representative. Gawahi, that is witness. Witnesses needed for a marriage are 2 males or 1 male and 2 females. Under Hanafi, Shafi and Ismaili laws, Ijab and Qubul should be made in the presence and hearing of witness, who must be Muslim and competent to contract their own marriage. Absence of witnesses will render the marriage irregular. Under Isna Ashari law, presence of witnesses is not legally required at the time of marriage. Mujlis-e-wahid, that is single sitting. Proposal and acceptance are to be made in a single sitting, signifying continuity of transaction. Proposal, when followed by acceptance, results into a marriage contract. The above-mentioned requirements are essential for a Muslim marriage. No other formality is necessary. It is a wrong notion to believe that there are any specific ceremonies of a Muslim marriage. Marriage feast or any other rites or rituals on the occasion of marriage are merely customary. It has nothing to do with the legal validity of marriage. The Delhi High Court in one case decided the validity of conversion of religious faith of the parties to the marriage. In Fahim Ahmed versus Navia Lakshmi, the twin problem before the court was whether there was a valid conversion. The court laid down that even assuming that there was a valid conversion of the respondent, the putative marriage lacked all essential requirements for a valid marriage under Muslim law, like offer, acceptance, 2 male witnesses, and free consent, etc. The Nikahnama itself did not indicate a requisite marriage. It is a testimony for a fact which had not been proved in the instant case. Therefore, the High Court held there was no valid marriage subsisting between the litigants.